Eric, I'm going to start with you. If you could give us sort of an update on the NFL concussion litigation and where you see it going.
Well, you mentioned 2011. That's when Ryan Easterling, he was safety for the Falcons, played between 72 and 79. He filed the first NFL concussion lawsuit. That was in the state of Pennsylvania. And that really permanently altered the course of football and hockey at the youth level all the way up to the professional leagues. So where are we today? Sort of in a nutshell, really, really quickly, you have his lawsuit is filed, morphs into a class action lawsuit, and ultimately the case, the sides settle at the trial division before Judge Brody. She approves the settlement. A non-cap settlement. Previously, the NFL proposed a cap settlement of $765 million. The court said no to that. This is a non-cap settlement. The case was then appealed to the Third Circuit. This was recently. The Third Circuit Court of Appeal affirmed Judge Brody and her approval of the NFL concussion settlement. This was a unanimous decision by the Third Circuit Court of Appeal. And as is generally the case, it has now been appealed to the U.S. Supreme Court. Let me say this, ballpark, about 0.01% of cases are heard before the U.S. Supreme Court. Usually the cases are heard if they're of national importance, if they're significant, morally or ethically, marriage equality, for example, or if there's a hanging Chad in some kind of election in Florida, by way of example. This does not fit the profile of the type of case the U.S. Supreme Court is going to hear. So you say, well, it's over. Well, Trevor, it's not over. Here's the thing, is that case, and that will bind about 99% of retired NFL players, a population of about 20,000 players. Thing is when you file a class action lawsuit and you settle, the players have the opportunity to opt out of that settlement. About 220 players have opted out, including the estate of Junior Seau, and they have filed their own lawsuits. And here's the key. This is really important, is that when a plaintiff sues in this type of case, and they're still alive, they're suing to get money to take care of themselves. When something as tragic as what happened to Junior Seau, who shot himself in the chest to preserve his brain for study, when that happens, the estate sues for something entirely different, and they have said it, and that's accountability and responsibility. So this is settling, but the flip side is you have these other cases that are proceeding, and it just takes one jury in one case to make a sort of a catastrophic monetary award.